Tladi, thank you for being with us once again at the Wayamo Foundation's conference here in Mauritius. And on behalf of everybody at the Wayamo Foundation, congratulations
Thank you.
on your appointment to the International Court of Justice. It's wonderful.
Thanks, and thanks for the invitation. It's nice to be back.
All right, so can you describe how African states are invoking and using international law, including outside of international criminal law, to address international crimes both in the region and further abroad?
I mean, there are many ways. So obviously that's, it happens in diplomatic circles, but I won't speak about those. I think that is an important way of invoking international law for addressing some of the violations, breaches, and international crimes. But lately we have also seen African states approach the International Court of Justice in contentious proceedings, in instances where there are allegations, and of course those allegations still have to be proven, where there are allegations of international crimes, in particular genocide. We know that there is the Gambia versus Myanmar case, and we know that that recently South Africa instituted also a case against Israel for its operations in Gaza. Which also is related to the commission of the crime of genocide, and this is not, of course, the first time. We know that historically, African states instituted some proceedings against South Africa, incidentally in the 1960s, in relation to the application of apartheid in Southwest Africa, Namibia. So there is a history. In addition to contentious proceedings, we've also seen that African states have been behind the request for advisory opinion in relation, first of all, to the situation concerning chargos, and also the advisory opinion concerning the situation in occupied Palestinian territory. So these situations also, in some sense, relate to the commission of crimes, and so there is a history and a pedigree, of African states being involved and using judicial mechanisms. In the context of the ICC, we know that recently, which is also some kind of a novelty, a group of states, including South Africa, have requested the prosecutor under Article 14 of the Rome Statute to open up investigations again in relation to the conduct of Israel in occupied Palestinian territories, in particular the Gaza Strip.
Just to follow up on that, it seems in a number of your examples, it's African states that are seeking to address international crimes through these various venues in very distant situations where you might not immediately think there's an obvious link between, say, the Gambia and Myanmar. What's inspiring that?
I don't know. I mean, I think that's the short answer, is I don't know. So one possibility is just simply a concern. That these crimes are happening, I guess, in the same way that that when European states act in different ways in relation to situations on the African continent, the things, well, there's an interest. I guess if one is pessimistic, so one might say, well, it's just pure politics. But one doesn't know. I mean, the reality is that one doesn't know. The fact is that it's happening, and that's really all that I can speak to.
So, in what ways do you think can African states, and this is a related question, of course, can they leverage? You talked about you've touched on diplomacy, you've touched on referrals, you've touched on the genocide conventions. In what ways can African states leverage existing international laws, or in what other ways can they leverage international law in order to achieve contemporary international crimes?
Okay, so in what other ways you're asking, right? So, well, I mean, there's obviously using their own national systems, right? So it's not always necessary to go to the the international system. One, you can use your own national system for addressing crimes committed on your own territory. I think that's very important. The other way is, of course, using your own national systems for addressing international crimes that may have been committed elsewhere, through universal jurisdiction. And I know that in some circles, universal jurisdiction is seen as a controversial concept, but I don't think the concept itself is controversial. There are certain things related to its application that might make it complicated. So just in terms of practicalities, obviously there's things like the collection of evidence, there's things like cost. In terms of law, there's the big question of immunity and so on, which we don't have to go into, but it's the tool itself, at least, is not a controversial tool as far as I'm concerned. There are things around the edges that are really important that have to be addressed first, but I think that's also a tool that could be used.
Could you talk a little bit more about that, about the role that Africa, or African states, I should say, has played in developing the application of universal jurisdiction?
That's an interesting question because, of course, one of the reasons that universal jurisdiction became prominent was because African states were pushing back against the exercise of universal jurisdiction, particularly insofar as it relates to the exercise of that jurisdiction against African leaders in European courts. And so, in 2008, you might recall there was a meeting in Kigali. It was a meeting of ministers of justice and attorneys general in Kigali, which adopted a decision to recommend to heads of state that African states must, within the General Assembly, within the United Nations, pursue the question of universal jurisdiction. And I believe the title was at the time something like "The Abuse of Universal Jurisdiction." I don't quite remember the title. So it was in that context that I think this concept became or at least a spotlight was shone on it. So yeah, so it's played a very interesting role in that respect, because I think, in a sense, initially there was a lot of reluctance. But that there was a constitutional court case in South Africa in which the torture docket case, in which essentially the court determined that the failure by the prosecuting authorities not to investigate a case which would be a universal jurisdiction case was unconstitutional, and so on. So at least we've seen the development of, even within the African continent, some support for universal jurisdiction. Again, I must just emphasize that that even this 2008 decision was, in my view, and I've always said this, it was based on a misunderstanding, because the critique was not a critique that was based on the concept itself. It was a critique that was based on other things, which may impact on the application of universal jurisdiction.
You've touched on this already, but around the world, and this isn't something that only occurs in African states, but there's often a reluctance or a hesitation to exercise universal jurisdiction. Sometimes for political reasons, sometimes for cost considerations, sometimes because perhaps there's concerns about whether people should expend, or states should expend, resources on things that happen abroad as opposed to domestically, and so on and so forth. And we saw that in the Habre case too, right? There was quite a lot of reluctance until finally this very significant universal jurisdiction case proceeded in Senegal. What do you think could help states, in particular African states, overcome that reluctance, especially given what you're saying, which is that it's not all that controversial. Yeah. Its application to particular cases may be somewhat controversial, but it could be exercised more frequently.
Yeah. I mean, I think it's useful to start with the Habre case, because often that's presented as a, and rightly so, it's presented as a positive example of a state or group of states on the African continent sort of banding together to to make it possible for the exercise of universal jurisdiction. But as you say, there was a lot of reluctance until the International Court of Justice stepped in. For me, look, there are political problems or political controversies rather that make it difficult in many instances to exercise universal jurisdiction. Part of it is that very often the types of crimes that you're talking about are types of crimes that are committed by world leaders. I mean, it's these crimes for which there is often a push for the exercise of universal jurisdiction, and that, of course, creates it creates political tension. When it's not leaders, it's very likely that the territorial state itself would want to exercise jurisdiction. So it's in these really difficult instances in which the individual's concerns might be protected by the state in which the crimes take place. This creates not only political problems. I think the political problems will always be there, but it creates not only political problems, it also creates legal problems. And sometimes these legal issues are used as an excuse for not acting, right? And so when a state says, well, we're not able to act because of the immunity. And so for me, I think it's really, really important that the immunity question is resolved. And it doesn't matter how it's resolved, but it has to be resolved. There has to be a point at which this stops being a debate, the different types of immunity and so on. So really for me, that's what it boils down to. There are some of the issues that will always remain. And so even if you resolve the legal issues, I mean, there's a cost issue that will always be there. There are different ways in which you can resolve it, capacity building and so on, and financial transfer. There are political problems that will always remain, but it is important at least to address this legal issue, because what this legal issue does also, in addition to itself being a barrier, is that it creates excuses. When a state is able to, but is not willing to act. So I think that has to be addressed.
Dire Tladi, thank you again.
Thank you very much.
Thanks for
it was a pleasure.
this conversation.
Thank you. It was a pleasure.